thank you for allowing us to have that extremely short break. Please call the next case.
Larry Kent et al. Versus Global Vision Baptist Incorporated et al.
Good afternoon.
Good afternoon, Your Honors. Ben Rose on behalf of the defendants' appellants, and I'd respectfully request 3 minutes of rebuttal time.
3 minutes, yes, sir.
Your Honors, good afternoon. This appeal that's before the court today regards the procedure involved in non-suiting not once but twice an action post-petition after a petition has been filed pursuant to the TPPA. For Judge Clement and Judge McBrary's benefit, before you smite me, we filed our appeal prior to when Flade and the Solomon case came down, and we were under the controlling authority, such as it is, of the Addison decision. So just
Mr. Rhodes, you're not suggesting you were upset to see me walk out of the door, are you?
I like Judge Bennett.
Well, you're the only one.
Appreciate
Stepped
it,
right into that one.
Yeah, that was too easy.
as I usually do, in the interest of full disclosure. So this was, when we filed our appeal, it was an Adamson appeal, if you will. But frankly, if we can step back for a moment, I don't think we get there, and hopefully it's a little messy so we don't have to go through all of the Adamson analysis and certainly our perspective. And that's because we have not just a purported non-suit without prejudice, but we also have a non-suit with prejudice, which was accepted in open court. And if I may, just by way of just a brief background, what happened here was a complaint was filed, and within 30 days, my folks, the defendant appellants, filed individually and on behalf of the entity a TPPA petition and then a motion to dismiss. Soon thereafter, a notice of non-suit without prejudice was lodged but not served, that's our contention, related to the claims against the individual defendant. We, under the Adamson regime, if you will, objected to that, and during the hearing on that objection, Your Honors, the counsel for the plaintiffs' appellees stood up and said, and I quote, "Your Honor, if the option is being placed on the table to dismiss the individual defendant with prejudice, I'm happy to do that right now," to what I then exclaimed, although I don't think I was required to, accept it. And that's sort of where we are. We then had a subsequent motion to enter a dismissal with prejudice related to that verbal offer and acceptance, and the trial court ultimately denied that motion, although I would submit that the rationale was not exactly clear how the court got there.
Counsel, I'm struggling to understand why an appeal of that denial doesn't have to be under Rule 9 or Rule 10 as an interlocutory appeal. I mean, this isn't we don't have a final decision, right, in this case. There's no final order resolving anything. So how are we here? And there's no, this is an interlocutory appeal.
Because respectfully, Your Honor, it's exactly what I believe the statute contemplates in terms of the appeal procedure within the TPPA, specifically 2017-106.
So let's talk about 2017-106 then. So the court's order dismissing or refusing to dismiss a legal action pursuant to this petition, a TPPA claim. But my understanding is the judge hasn't yet had a hearing even on the TPPA claim. So there's no decision one way or another what should happen with the TPPA claim at this point, right? We haven't had any action under the petition, the TPPA petition, right?
I would respectfully disagree, Your Honor. Okay. And the reason is because I believe when you file a TPPA petition, the TPPA statute and its procedures are immediately invoked. And that may be some divide in terms of Amundsen and where maybe some of the other jurisprudence is on that.
Counsel, how do you square that position, though, with the court's order staying the proceedings? Because in that order, the trial judge seems to be making clear that she at least thinks that there's more to do on the TPPA petition.
Well, that was actually an order, Your Honor, that was entered ex parte after our notice of appeal was already filed, so I'm not sure exactly what was going on in terms of what the trial court is thinking. I can tell the court that there were many other issues involved other than just the TPPA itself, and we had, I think there was a total of 2 motions to dismiss that were pending at the time that we filed that. But Judge Usman, to your question, there's no other path of relief. I mean, I don't know how you read that language any other way than here.
Couldn't you pursue a Rule 9? And couldn't you have asked for interlocutory appeal? I mean, you think the trial judge has erred here, that they should have been, she should have approved, ordered, directed dismissal of Pastor Locke based upon the statement in open court and your acceptance of it. And isn't interlocutory appeal under Rule 9 a mechanism for having that potentially heard by the court?
I agree with the court. It's an alternative mechanism. I don't think it's required, particularly when you have the specific procedure that's outlined in 106.
All right, the procedural posture of this case, the trial judge did not dismiss the underlying action. So the underlying action against Pastor Locke is still, if I'm correct here, it's still outstanding at this point, the suit against him. And so given that, the TPPA claim, the sort of series of cases where we have voluntary dismissals, and then we have appeals, and we get into attorney's fees issues on TPPA claims, how are they applicable here, given that there is no dismissal of the suit against Pastor Locke, and there's no dismissal of the TPPA claim? And doesn't that put this case in a very different procedural posture than the cases that you're referencing?
There was a lot of information there, so I may not have followed you correct. I wanted to follow you at one point, but until the end, I think I may have.
Unlike the other attorney's fees cases, and this court has had a series of attorney's fees cases, and Tennessee Supreme Court's grappling with all of this in terms of how you look at attorney's fees in these TPPA dismissal cases. And you raised some very interesting arguments in your brief about challenges related to somebody who files a TPPA claim, and you have a voluntary dismissal, and is that really, how does that square with the TPPA? I find that part of the brief intriguing, but isn't it procedurally different here, given that we don't have a dismissal? And we still have an ongoing suit where the claim against Pastor Locke that wasn't dismissed here, unlike those cases where there was a voluntary dismissal and we have the case gone away and then the TPPA ends up going away in connection with it. Here, they're both still live, aren't they? Doesn't that make it different than a sort of more conventional, at least, 2017-106 case?
Oh, it's certainly we will concede that it's not a conventional 106 appeal. Absolutely, I agree with that.
What brings it within 106? What brings it within that language of the court's order dismissing or refusing to dismiss a legal action pursuant to a TPPA claim? How do you square that?
Well, you just read the statute, Your Honor. Literally, the trial court refused to dismiss with prejudice the action against the individual defendant appellant in the face of a TPPA petition.
It's not a TPPA petition, though, that the court declined to dismiss, right? And it's not that it's not as if you were saying I'm dismissing my TPPA claim and the other side stood up and shouted accepted. It's not a dismissal of the TPPA, is it?
Well, that's the argument of the appellees, and if, with all due respect to that argument, I don't think you get to pick and choose in the face of a TPPA petition. So in other words, the argument they've advanced on the other side is, look, you filed a TPPA petition and you filed a motion to dismiss. We, as the plaintiff appellees, we get to choose how we non-suit with or without prejudice, in this case it's both, our claims, and we're going to pick the motion to dismiss it in the face of the motion to dismiss, that we're non-suiting those claims so that we have no other penalty, frankly, other than, well, maybe not even the loser pay statute. I don't think you get to do that because, as I understand the law, after you file your TPPA petition, you're then within the rubric of the TPPA itself. And literally what happened here, not once but twice, was the trial court said in the face of a TPPA petition, I'm going to refuse to dismiss this lawsuit given the TPPA petition that's out there. That's literally what the court said. I think I would also emphasize in terms of appellee's argument, one of the things they've said in their briefing is, well, this notice that we contend was not even filed, it was lodged and not served, Well, you have to characterize that notice as a notice only related to the motion to dismiss. Well, that's not what it says. There's nothing within the notice itself that would put anyone, let alone my clients, on notice that, hey, I'm only going to non-suit as it relates to certain claims, but not other ones. By the way, the ones that have the penalties. I'm not going to do that. And then the criticism of our motion, Your Honors, related to that was that, there's a flat statement within their briefing that says, this is not a motion, this is our motion they're talking about, this is not a motion related to the TPPA. I think it's the second paragraph, Your Honor, that talks about the TPPA applying. And certainly if Your Honor is correct that this is not the correct posture in terms of the appeal or the underlying argument, the trial court could have said that. The trial court never said that in its ruling. It never said, look, I'm not even going to regard these TPPA issues, all of which, by the way, have now been waived by the appellees because they haven't addressed them. I'm only going to look at the motion to dismiss or maybe the general law, I guess, related to non-suits. I'm not sure what was going through the trial court's mind. I am pretty sure and adamant that she erred in terms of making the rulings that she did. If I could go back to my argument a little bit in terms of the way we think you get there. Obviously, two ways you can get there, Your Honor. The easiest and most practical way to get there is if you look at the oral non-suit that was made in open court and accepted. If you look at that, and particularly in terms of 105E, which talks about dismissals within the TPPA being with prejudice, I think you get there and it's very easy. The Beatty case that was relied upon doesn't apply here. That was a case where there was a dismissal anyway, and there was no showing of an analysis of prejudice by the trial court related to Beatty. Then the other way is if Your Honors want to look at both of the notices, the notice of non-suit without and the verbal offer with prejudice, obviously taking those two together, you have an adjudication on the merits. We would ask that the trial court be reversed.
Thank you, sir. We'll hear from you further on rebuttal. Good afternoon.
Good afternoon, Your Honors. May it please the court, Ben Lewis on behalf of the appellees, the plaintiffs originally in this case, Larry Kent and Linda Kemp. I'll start where Your Honor, Honorable Usman originally started with the questioning, which is under 2017-106, our initial issue is how does this case get to this court? How is it properly here? You cited to Rule 9 and Rule 10 of the Rules of Appellate Procedure for interlocutory appeals. That's not how we got here. The notice of appeal that was filed in this matter plainly states it was filed under 2017-106, which is the TPPA's provision regarding an immediate right of appeal for either grant or denial of a TPPA petition and motion to dismiss. In this case, we never got to a TPPA petition. In fact, it was scheduled for shortly after this order came down for a trial on all of these issues. A motion to dismiss, TPPA, all of those have been lingering and compiling upon themselves for quite some time to the point where there were likely upwards of 10 motions that were set for that day to be heard. But we didn't get there. Shortly before that time, a notice of appeal was filed, specifically citing 2017-106, as it relates to an order issued or entered on February 27th, 23, on the motion for entry of dismissal with prejudice regarding Greg Locke in his individual capacity.
Counsel, has there been any motion to dismiss the TPPA claim in this case? Has there been a motion filed to dismiss the TPPA claim?
To dismiss the TPPA
The
claim
TPPA
on my
claim,
part.
yes, on your part.
There has been a response in opposition to that, but not a direct motion to dismiss the TPPA
Okay, so
claim.
you haven't moved to dismiss the TPPA claim? in this
My understanding of the statutory scheme, Your Honor, if I may, is that once that is filed, the court, and this comes from, obviously, there's a growing kind of breadth of cases this court has issued and now up at the Supreme Court on this TPPA that continues to I think, compile on itself to give us clarity on it. But I go back to originally the Rice versus Rock Creek case. It's from a few years ago, where the judge in that case, one of the kind of original TPPA cases, and now analyzed it under Rule 12. And this court kicked it back down and said, look, you've got to go through a procedure to decide whether the TPPA even applies to begin with. And I think that's really where I think we can start on this, is that the TPPA there's never even a determination of whether it applies in this situation. And I think you can characterize a motion to dismiss or a response in opposition to the TPPA as being one and the same, I think, in this regard.
No determination here, though, and no,
No.
has there been any hearing?
There's been no
Really?
hearing. That was scheduled, I apologize, Your Honor, the last order that was in this that I think opposing counsel characterized as ex parte, which I would strongly disagree with that, considering it was a scheduled hearing in open court. At that hearing, that was when everything was scheduled to be heard. That is when the court issued an order to stay the proceedings pending the appeal. And we have never gotten to a hearing on the merits of the TPPA petition. There is no order suggesting that. The hearings were scheduled, but they never happened. So I think when we look at, I know Rice versus Rock Creek was implicate free speech, freedom of association, et cetera. And then if they do, it's dismissed unless the plaintiffs in the case can then establish a prima facie case at that time. And we've not gotten there. So that's where I come to my initial issue, and what I pointed out in my brief is that I don't believe this is properly before this court. I don't believe there's been anything done that would give a right to an appeal under 2017-106. Even if we consider this issue of the denial of the non-suit, or the motion to enter a non-suit, it doesn't implicate in any way, shape, or form the TPPA, because there's been no determination even as of yet whether the TPPA applies to this case, whether it implicates free speech or the freedoms that are contemplated under the TPPA. So for those reasons, it's our position that this case, as an initial matter, is not properly here. This was not the appropriate mechanism for which to get us before this Court of Appeals. It should have been either Rule 9 or Rule 10 that took us here. If that was still an appropriate avenue, I would have objected to that as well.
Counsel, opposing counsel in briefing gets into the merits of this case. Let's assume for a moment there is jurisdiction over this case. One of the things that opposing counsel points to is a complaint in this case references Pastor Locke, the Global Vision Baptist, the religious beliefs and views of the pastor and the church. And I am curious in terms of the complaint, and what is the role of those references to, and what does it matter that Pastor Locke has certain religious beliefs, or that the church has certain religious beliefs, when we're considering whether there's too much water runoff?
Correct. And I think, candidly, the reason that is there was to lay groundwork for why has this become such an issue within a broader scope, because this is not really before this court, I don't think, but if I may, if you look at the broad scope of this, there are ancillary lawsuits that have gone on regarding this from individuals within the county. There's a county lawsuit. There's lots of stuff going on with this that has led to it going from why would this be an issue to begin with, to why is it such a major issue for my clients sitting across the street.
But you're not suggesting that enforcement of for example, zoning ordinance or nuisance should look different based upon the religious beliefs of the entity. I mean, if it's there, you can't have that many cars parked there. You can't have that many cars parked there. Whether and you're not suggesting that there's something about the religious beliefs that would justify.
No, sir. In no way, shape, or form am I suggesting that. In the light of what has gone on in this case, could I or would I have gone backwards and maybe recrafted the factual portion of that? Maybe, but I don't think just simply because it's there and trying to lay a groundwork for why this is an issue, do the allegations of our request for relief implicate some restraint upon freedom, is what I'm saying. The impetus of our case is just because they are a religious organization, that doesn't exempt them from the normal procedures and mechanisms everyone has to go through to have any type of building, whether that be residential, commercial, what have you, in that area, and they've not followed those.
You would agree, though, that their beliefs are immaterial to whether there's a violation?
That's correct. And that's been our position throughout this, is that they are immaterial to our request for relief. Your Honor, if we get through to, I apologize, let me back up. Your Honor has touched upon the merits of the case, and there have been, in the lengthy reply brief, there were arguments that those have all been waived by us at this time. The issue I take with that, Your Honor, is, again, going back to, we have not had a ruling upon that. There's no order that suggests that there's been a finding on any of the meat of this TPPA petition or the complaint. We simply have a non-suit. That's all we had. So I don't find it.
Do we have a non-suit here? And is it in terms of the current posture, right? There's still a pending claim. Again, we may have an attempted non-suit, but we don't have an actual non-suit in terms of the current procedural posture. Your clients are still suing Pastor Locke and Global Vision, and Pastor Locke is suing your clients in connection with the TPPA, and all of that's still pending, right?
Yes, sir. As we sit today, this is essentially no different than it was 30 days after when they filed their TPPA petition. This case is in the same posture essentially as it was at that time. Nothing has changed. I will admit we did attempt a notice of non-suit. Obviously, that is an issue that's kind of floating out there to be determined by the Supreme Court if it makes a decision on that as to whether or not a voluntary non-suit can be taken in the face of TPPA. I know this court has opined on that in a couple of occasions. But that's one of our issues, although at this time no non-suit has been given, no non-suit has been granted. I go next to the issue of the motion for entry of dismissal. At that time, at the hearing on the original non-suit, there was a statement made, a couple of statements in court, but I would suggest to your honors that there's no transcript, there's no proof before this court. I understand it was simply a legal matter, but if we're going off of statements that occurred in court, simply transposing those into a brief is not the appropriate way to do it, in my opinion, and I'm not seeing that done. There would be nothing before this court that would suggest to you what was said during that hearing, and it would require everyone to put forward the entirety of what was said. Regardless, the court's order, which the court speaks through its orders, the court's order on the motion for entry of the dismissal clearly stated that it was verbally stated, verbally withdrawn, and the court accepted that withdrawal of the non-suit on my behalf, on behalf of my clients at that time. Regardless of my opinion on what the attempt was with those statements in court, it was allowed to be withdrawn. And it doesn't fall, I think this is really where the trial court went with this, was it doesn't fall under Rule 41.01 to allow an oral non-suit outside of a trial situation or a jury trial.
I thought it just had to be an open court.
The statement, or the Rule 41.01 specifically states that a non-suit may be taken by the filing of a written notice followed by an order, or an oral notice of dismissal made in open court during the trial of a cause.
During the trial, okay.
Yes,
Thank you.
So it states that, and then it has another provision that doesn't apply related specifically to jury trials. It has to be done prior to the jury coming back. But it does specifically state during the trial of a cause. But regardless, there is authority out there, and I understand the argument of prejudice that's been made in the reply. In the case of Beatty v. McGraw, it's an older case, 93, where the only one that I could really find that was on point with this issue, where a notice of non-suit was taken at the beginning of the case. At the end of the case, this was during the trial, notice of oral non-suit was given, and then at the end of the trial, when the other side asked for their attorney's fees and their damages for having the non-suit taken, the individual who requested non-suit withdrew it verbally, said, I no longer want that. If they're going to ask for damages, I withdraw my non-suit. The court accepted that. That was then appealed to this court, and in the Beatty v. McGraw case, the court stated that that was essentially an abuse of discretion type of situation for the trial judge. It was within their purview as the kind of ruler of the courtroom, of the procedures there, to determine whether or not the withdrawal or the oral giving of a non-suit was appropriate. And this court stated that there was no problem, there was no abuse of discretion there by the trial court to allow the withdrawal of the non-suit, which is exactly what happened here, which is why in my brief I think that issue specifically falls under an abuse of discretion standard for this court. And unless this court finds that the trial judge, Judge Knight, abused her discretion in allowing the withdrawal of that non-suit, then it would stand as ordered. And we are back in the position that Your Honor has stated, where we have no non-suits and we have a case that's still pending and no determination on really anything at this point, other than to go back and pick it back up where it was. for those reasons, we have requested attorney's fees. I've seen the reply on that as well. The reason being is that there are certain rules, and we heard a lot about it in the last oral argument, Your Honor, in their case, motion to alter amend. We have rules for a reason. And in this situation, there's a very specific statutory scheme. I understand there's not a lot of case law on that, but when there are mechanisms for appealing interlocutory under Rule 9 and Rule 10 of the Appellate Procedure Rules, and someone goes the opposite way and says, no, I want to file under a different route, there's a reason for that. And I think that reason's been stated. It's been stated that that was because it was under the TPPA. To be honest, regardless of how far we bend, I don't think we can find that this non-suit had anything to do with the TPPA or the allegations made in their motion to dismiss under the TPPA. I think it was simply an argument over whether or not a non-suit should be given. And at this time, it hasn't been given. So for that reason, just simply looking at the language in 2017-106, where it states, the court's order dismissing or refusing to dismiss a legal action pursuant to a petition filed under this chapter is immediately appealable. There was nothing done pursuant to 2017-101 and its progeny after that. Nothing was done. This was completely under Rule 41.01 as the basis for it, and because of that, I've requested, it's my position that a plain reading of this statute would give any attorney the knowledge that that's not the appropriate avenue to appeal this court's order from February 27th. So for that reason, we requested our attorney's fees. Unless the court has any other questions, I think I'll conclude there. Thank you.
Thank you.
A few points, Your Honors. As we pointed out in our reply briefing, among other issues that were waived by the appellees, the request for attorney's fees specifically under the TPPA has been waived, and there is law on that. You have to request them in the briefing, in the appellee's brief, I believe, and that was not done. Counsel opposite didn't say it, but what he asked for was he wanted frivolous appeal damages in this case, where that there are no cases that specifically address this. I respectfully submit, I understand sort of where we are post-Amundsen, but you know, our contention is if you don't observe 106 being the avenue to address these types of issues when there should be a non-suit with prejudice, then the entire purpose of the statute has been thwarted. And much like the Donovan case that we cited, I don't think respectfully you can do that. I'm here to answer any other questions that the court has.
It's a merits question and also a jurisdiction question. On the merits front, I wonder, how do you see the interplay between the complaint and the U.S. Supreme Court's decision in the Masterpiece case in terms of, you've raised some concerns about the complaint. I'm curious if you see a connection between that and the Supreme Court's decision in Masterpiece.
Your Honor, you're going to have to elucidate me a little bit about Masterpiece because I'm sorry, I'm not a friend. I'm just a state practitioner. I apologize.
In terms of enforcement in Colorado and enforcement of generally applicable law in connection with particular views on religious beliefs, do you see a connection between the complaint and enforcement of what may be a neutral law, but where religious beliefs are coming into the enforcement?
I do, Your Honor. Obviously, that's the Cake case, and I apologize for not knowing the title right off the top of my head. I should know that. Smite me for not doing that. But yes, I do see a connection there. And look, you know, as we pointed out in the briefing, after we attacked these allegations, and there is no reason for these allegations other than to color these defendants as people who are, you know, for lack of a better term, out of step with traditional religious views that relates to their specifically requested relief, which is not to abate the problem, it's to stop the church from operating. That is, if you look at their requested relief, they ask for an order from a court saying, shut down this church. And I respectfully submit that that is not something that we would normally entertain in sort of the neutral principles civil courts of this state, in fact, this country. So I do think that there is the interplay there. And I think that, you know, as it relates to applicability, number one, they have waived those issues. We briefed those in very, very detailed And they didn't respond at all and say that there was any justified reason why the TPPA did not apply to them. Yes, they filed a response in the trial court, but they did nothing in this particular court, and we thoroughly briefed that. And remember, all we have to demonstrate is a prima facie case, and certainly the broad language of the TPPA would include religious discrimination, including statements, and they even admit that there were statements made within the allegations of their complaint. We would ask that you overturn the trial court, reverse the trial court, dismiss the individual defendant appellant with prejudice, and provide us with all the relief accorded under the TPPA. Thank you.
Thank you very much. Thank you both for your arguments. We'll take this matter under advisement. That concludes the docket.